Protect your AI innovation. IP strategies you need. Why AI makers must secure IP rights. So IP such as patents and trademarks represents up to 90% of all AI company values. You look at Apple, they have a few buildings. They have that brand, which is worth billions, and then they have patents that protect their products. They outsource everything else. So for Apple, IP was probably around 80 to 90% of the company value. You, as a startup that don't manufacture physical products, are also in the same boat. Without protection, competitors can freely copy your technology. Therefore, investors demand strong IP portfolios before, during, and after funding. You need to patent your AI breakthrough. So let's take a look at Tesla. They secure patents for autopilot's sensor fusion and object detection. Google patented its search generative experience. Samsung protected the AI-powered drones with face recognition technology. In all of these cases, human inventors are required, so AI cannot be listed as an inventor. So AI-generated work needs human involvement for protection. If you just use AI LLM to design a new drawing, music, or a book, that is not protectable. And there are tools that can detect the output, let's say a text file, and detect whether or not that was generated by AI. You need to have human control of the AI in order for that work to be copyrightable. And registration of the work strengthens your legal position in disputes. Different countries have different rules. China is very pro-AI. The EU and the US are more similar in position in that they require a human inventor to be copyrightable. What are some smart protection strategies for AI software company? First of all, you need to cluster your patent. When you file multiple patents around one technology, it strengthens your portfolio. This is no different than investing in the stock market. Would you put all your money into one company, no matter how strong it is, or you prefer a basket of strong companies? Most advisors would recommend a portfolio approach. You should apply the same thing to patent clustering. You can use the patents for cross-licensing purposes. You can strategically share complementary technology to complementary companies that don't directly compete with you, and then that way it allows you to enter new marketplaces. Make sure that the company has ownership of the employees' innovations and make sure that it's directly stated in the employment agreement. That way, you as a company get the benefit of the employees' work. Use NDAs strategically. Protect your algorithm and training method through trade secret. And NDA would be a good way to document your particular trade secrets are valuable to you and that you exercise control in giving selected people access to your technology. So with all that in mind, how do you go about building a portfolio? For most startups, typically the founders would create a prototype and test it with various customers to see if it has traction. Once it has traction, then you go and talk to an investor and then you scale up that process. All along this process, you can start building your patent portfolio. In one example, I've helped Invisalign at the early stage. I built some of the original patents that Invisalign technology is based on. In the first few years, we built around 10 to 15 patent applications. As the company finds traction and raises into additional series, we start increasing it, and by the time it goes public, the company has around 30 to 50 patent applications, somewhere in that range. And that's a layered approach to protect the company from competitors who might copy them. And so in that particular example, first, we patented the original concept of using aligners to move the teeth. Then doing the implementation, then you have specific things that you need to innovate. For example, how would those aligners grab onto teeth? And we would have things that we call attachment that you put onto the tooth, and then you have a corresponding mold in the retainer that would grab onto those attachment, and then the retainers, it will grab the teeth and move on with that. You also run into issues on computer-aided modeling of the teeth and how it's moving. So there's a series of patents on CAD patent. So you have 3D printers that would create a positive model of your teeth upon which the aligners would be created by slamming plastic sheets on top of those 3D models. And how are those things clean? And so we have different patents on that. And then, of course, you have the orthodontist-facing tool as well. So those are examples of how the patents can be cross over into a bunch of different areas. And that's how you can think about building your portfolio that way. In addition, every year you would have new improvements. And so before you release a new product, you would then go in and look at what's valuable, and you would build a portfolio based on each iterations of product improvement. Let's talk about process timeline. We recommend that you do a light search just to validate the concept that is novel, and so you avoid wasting money on patents that may not be novel. You make sure that the invention is novel, but you're going to rely on the inventor's expertise and knowledge of the space. What we should do is spend all the time documenting and pulling that information from the inventor and putting it into the patent application. The more details, the better. The reason for that is if you have, let's say, if you have a one-page back of the envelope application versus a 50-page patent application, of course, somebody who's trying to solve a problem in the same space, if you have just a high-level disclosure of a back of the envelope, it's very likely that somebody across, the opposite side of the globe would have thought of the same solution, right? But when you go down into a very specific way of implementing it with 50 pages of details, the odds are increasingly higher that no one has come down with that particular approach. So I tend to favor very detailed description. Along with that is provide a lot of figures. The drawings are valuable because, a photo is worth 1,000 words. So apply that to the drawings as well. So have as many, picture diagrams of how the invention operate, as many views of a mechanical device as you can, as many flowcharts. Throw in pseudocode. Those are all details that's going to help you document the differences in case you run across an unknown piece of prior art a year or two downstream during prosecution. You should also, for software, you should also throw in as much detail showing how your invention is better than the existing method, because that helps you show that you meet the patentable subject matter test. So provide details comparing the effectiveness of your solution versus the existing art. And then that goes a long way to show that you have improved computer performance somehow. So that's the application side of it. In the office action, once you file it, roughly 18 months to about 2 years, you're going to get picked up for examination. And the examination isn't there to be good news for you. The examiner is there trying to show that your invention is obvious or somehow has been done before, right? So the more details this is where the details in the application will come through and help you in prosecution. The more details you have, then you can argue that the references that the examiner used when combined wouldn't work, or it wouldn't work in the same way, or it's missing the details. So how are you going to overcome the examiner? We in particular try to expedite prosecution by, when we get a rejection coming in, we will first make a draft for the inventor to review. We will sit down and discuss that draft with the inventor. They'll add some additional insight that we missed. Then we send that to the examiner, and then we request a meeting where the inventor provides a human face to the invention. And then we'll talk to the examiner, and through that exchange, it's a give and take, right? We're going to tell him why he's wrong, and he's going to tell us his particular view of how the things can be combined. And through that process, we learned what is bothering the examiner, and then we can tweak the claim language to address that, and that's the best way to negotiate your way through the prosecution. After the patent issues, then of course you have to make sure that you do every 4 years as maintenance fees due. You also need to scan the universe for infringers and your competition. The patent is there to be used, right? It could be used to block competitors from coming into your space, or at least slow them down, right? If you see somebody who's emerging and they're about to latch onto your novelty area, you send them, you meet them, and then you just say, hey, look, we think that you might be coming too close to this patent, so please avoid from it. That's one way of slowing them down. Once you find somebody is encroaching in your space, you should amplify your portfolio into that space, so that way it's harder for them to design around and slow them down. The more application you have, the slower they'll get. And by doing that, you win by getting more time and coverage for them in case things get into litigation. You can have more claim against them. And the more patents, the harder it is for them to argue that all patents are obvious. In short, don't risk losing your competitive edge. Build proper IP protection for your legal defense. Is your AI company's most valuable business asset. Don't ignore that. If you have questions, visit us at patentpc.com. We're here to help you. We look forward to meeting you.